You are not the executor of your parents' estate. You are the target of a debt collector who has been waiting patiently for your mother to die. That debt collector is the state of Florida. It has been a creditor of your mother's estate since the day Medicaid started paying for her nursing home care, 3 years before she died. You did not know this. The probate court did not flag it. The will did not mention it. The deed showed no lien. Every document you reviewed as executor said the house was clean. And then, 30 days before closing, with a buyer under contract and movers scheduled, the title company calls and tells you that the Florida Agency for Healthcare Administration has filed a Medicaid Estate Recovery claim against your mother's estate for $94,000, and that claim has to be resolved before the sale can close. You are not imagining this happening to you. It happens to tens of thousands of executors in the United States every year. Most of them are adult children, managing their first estate, grieving their parent, and discovering, at the worst possible moment in the process, that the inheritance they expected has a creditor nobody told them about. Diane Castellano is 52 years old. She lives in St. Petersburg, Florida, and works as a marketing director for a regional healthcare staffing company. Her mother, Rosalind Castellano, lived in a 2-bedroom ranch house in Tampa for 38 years. The house Diane grew up in, the house where her mother kept a collection of ceramic birds on the windowsill above the kitchen sink, the house with the orange tree in the side yard that has produced fruit every winter since 1991. Rosalind passed away in March 2026 at the age of 84, after a 4-year decline that included 2 years of skilled nursing facility care, paid for first privately and then by Florida Medicaid starting in 2023. Diane was named executor in her mother's will. She filed the will for probate in April 2026, a straightforward process. Rosalind's estate consisted primarily of the Tampa house, valued at $268,000, and a checking account with $4,200 remaining. Diane retained a real estate agent in May, listed the house in June, and accepted an offer of $271,000 within 9 days. Closing was scheduled for July 28, 2026. Diane coordinated with movers to clear out her mother's belongings, the ceramic birds, the furniture, 4 decades of a life, over 2 weekends in June and July. On July 1st, the title company conducting the closing search contacted Diane's probate attorney, a search of Florida's Medicaid Estate Recovery records. A database the title company checks as a matter of routine practice in Florida, though this practice is not universal across all states, revealed an active MERP claim against Rosalind Castellano's estate. The claim, $94,310, representing the total Medicaid expenditure on Rosalind's nursing home care from 2023 through her death in March 2026. Diane had never seen this claim before July 1st. It was not in her mother's will. It was not mentioned in any document Diane had reviewed during probate. It was not recorded as a lien on the property. Florida, like most states, does not record MERP claims on the property title during the recipient's lifetime. The claim exists as an unsecured debt against the probate estate, surfaced only when the estate is settled, or, as in Diane's case, when a closing search specifically checks for it. Diane had a buyer waiting. She had a closing date 27 days away. She had movers already paid for 2 weekends of work. She had told the buyer's agent that everything was on track. And now her probate attorney was telling her that $94,310 had to be resolved, paid, negotiated, or formally appealed before title could transfer clean to the buyer. The math: a sale price of $271,000 minus the realtor commission of $16,260 minus closing costs of approximately $3,800 minus the $94,310 MERP claim leaves Diane's estate and ultimately Diane and her 2 siblings as beneficiaries with $156,630 to split 3 ways, $52,210 each, down from what they had projected as a roughly $84,000 share before the MERP claim surfaced. The state's claim consumed nearly 35% of what should have been Diane's mother's gift to her children. That is the crime scene, not a trap that snapped shut years ago, a trap that surfaced in the final month, threatening a closing already in motion, with a buyer, a moving schedule, and a family in the middle of grieving expecting it to resolve cleanly. If that phone call, the title company, the unfamiliar claim, the 27 days to figure it out, lands the way it should, smash that like button right now, because everything I'm about to show you is what Diane's attorney did in the following 3 weeks to reduce that claim, protect the closing, and recover money that most executors never know they have the right to fight for. Let's build the complete picture of how the MERP claim was calculated, why it surfaced when it did, and what specific mechanisms exist to challenge it. Because Diane's $94,310 claim was not a fixed, unchallengeable number. It was a starting position. The suits at the agency want me to remind you this is not financial or legal advice. It is a survival guide for an unguarded vault. Talk to a probate attorney and an elder law attorney before responding to any Medicaid Estate Recovery claim or proceeding with a property closing where a claim has surfaced. Why the claim surfaced at closing and not earlier. Under Social Security Act, Section 1917B, states are required to pursue Medicaid estate recovery against the probate estate of any recipient who was 55 or older when receiving long-term care benefits. Florida implements this under Florida Statute Section 409.9101. The claim itself becomes legally collectible once the estate is opened, meaning the personal representative, in Diane's case, has an obligation to address known and reasonably ascertainable creditor claims, including Medicaid estate recovery, before final distribution. The gap. Florida does not require AHCA to proactively notify the personal representative of a pending MERP claim at the time probate is opened. The personal representative is technically required to publish a notice to creditors as part of the probate process, which Diane's attorney did in May 2026 as standard practice as, and creditors, including AHCA, have a window to file a claim against the estate in response. AHCA's claim was filed in response to that published notice. But AHCA's internal claim filing timeline does not always align with a seller's transaction timeline, and the claim does not appear in any public record search that a typical executor would think to run. It surfaces specifically when a title company runs a Medicaid lien search, which is not a universal practice across every title company or every state. The claim itself, what Florida can and cannot recover. Florida's MERP claim of $94,310 represents the documented Medicaid expenditure on Rosalind's nursing facility care. Under federal law, the claim is limited to amounts Medicaid actually paid, not amounts billed, not amounts the facility charged privately, but the Medicaid reimbursement rate, which is typically lower than private pay rates. Diane's attorney requested an itemized accounting from AHCA, a right every personal representative has under Florida Statute Section 409.9101(5). To confirm the claim reflects actual paid amounts rather than billed charges. The itemized accounting revealed a discrepancy. AHCA's initial claim included $6,840 in charges from a 6-week period in late 2023 when Rosalind was briefly transitioned to a different facility during a Medicaid eligibility redetermination, during which her coverage had a documented gap. Medicaid cannot recover for periods when the recipient was not actually covered, regardless of what was billed during that window. Diane's attorney flagged this discrepancy, and AHCA's accounting team, after a documentation review that took 11 days, reduced the claim from $94,310 to $87,470. The hardship waiver, Florida's specific criteria. Every state's Medicaid program under federal policy guidance in the State Medicaid Manual Section 3810.d must maintain an undue hardship waiver process. Florida's hardship waiver, administered through AHCA, allows an heir to contest recovery on specific grounds. The property is the heir's primary residence, the property is the heir's sole income-producing asset, or recovery, would result in the heir becoming eligible for public assistance. Diane does not qualify for Florida's hardship waiver in the traditional sense. The Tampa house was her mother's residence, not Diane's primary residence, and Diane has stable income from her marketing director position. The hardship waiver pathway, while real and federally mandated, was not available to Diane's specific situation. This is an important clarification. The hardship waiver is not a universal escape hatch. It applies in specific circumstances, and most adult children selling a deceased parent's home as part of normal estate settlement, rather than living in the home themselves, will not qualify. The actuarial and procedural audit, where the real reduction came from. The more productive challenge in Diane's situation was not the hardship waiver but a procedural audit of AHCA's claim calculation. Diane's elder law attorney, brought in specifically for the MERP negotiation after the probate attorney identified the claim's complexity, requested documentation of every individual payment AHCA made on Rosalind's behalf, cross-referenced against the nursing facility's billing records for the same period. This audit identified a second discrepancy. AHCA's claim included a $4,200 charge for a hospital stay in early 2024 that should have been billed to Medicare Part A, not Medicaid. Because Rosalind retained Medicare eligibility throughout her nursing facility stay, and the hospital admission was a covered Medicare service, not a custodial care service that Medicaid would have funded. The elder law attorney flagged this as an improper inclusion. AHCA's review confirmed the error and removed the $4,200 from the claim. Combined reductions from the itemized accounting review and the procedural audit, $6,840 plus $4,200, totaling $11,040. The claim moved from $94,310 to $83,270, an 11.7% reduction achieved through document review alone, before any negotiation of the remaining balance occurred. Tell me in the comments right now, has anyone in your family served as executor for an estate and discovered a Medicaid Estate Recovery claim during the process? What state, when in the process, did it surface? At probate filing, at closing, or after the sale was already complete? This thread needs to map how widely this discovery timing problem is affecting families across different states. Here is the open loop I need you to hold. There is a specific timing strategy available to executors, used by experienced probate attorneys but almost never volunteered by AHCA or any state Medicaid agency, that can delay the final settlement of a MERP claim long enough to complete a property sale on schedule, while preserving the estate's right to fully negotiate the claim amount afterward. It does not require paying the claim before closing. It does not require the buyer to know any of this happened. Hold that. We're almost to the strategy. Let's name the structural gap that produces this exact discovery at closing scenario for thousands of executors every year. The Medicaid Estate Recovery Program was mandated by the Omnibus Budget Reconciliation Act of 1993, implementing Social Security Act Section 1917(b). Every state must pursue recovery from the estates of Medicaid recipients aged 55 or older. The federal statute establishes the recovery obligation. It does not establish a uniform proactive notification requirement that would alert families to a pending claim before the estate settlement process begins. States have discretion in how they administer recovery. Some states, Minnesota, Wisconsin, and a handful of others, send a notice of intent to file a claim directly to the personal representative shortly after the Medicaid recipient's death, giving the executor early warning before any property sale is initiated. Florida is not one of those states. Florida's process relies on the probate notice to creditors mechanism, a publication requirement that technically gives AHCA an opportunity to file a claim, but does not require AHCA to proactively reach out to the executor with the claim amount before the executor has already initiated other estate actions, including listing and selling real property. The result, an executor in Florida, acting in good faith, follows the standard probate timeline, files the will, publishes the creditor notice, begins administering the estate, including listing the house for sale, without any signal that a six-figure claim is queued up against the estate until a title company's closing search happens to catch it, or until AHCA's own internal processing catches up and sends a claim letter, which can arrive at any point in the probate timeline with no fixed deadline tied to the executor's transaction schedule. The title insurance industry's role compounds the gap. Not every title company in every state routinely searches for Medicaid estate recovery claims as part of standard closing due diligence, because MERP claims are not always recorded as property liens. They are estate-level debts that do not always appear in a standard property title search. Some title companies have developed specific protocols to check state Medicaid recovery databases as a matter of practice, particularly in states like Florida, where this has become more common after high-profile cases of failed closings. Other title companies in other states do not run this check at all, meaning some families discover the claim only after the sale has closed, when the state pursues the estate or the personal representative directly for the unpaid amount, a substantially worse position than discovering it before closing. Diane was, in a specific sense, fortunate. Her title company's practice of running the Florida AHCA lien search caught the claim before closing, giving her attorney time to negotiate. An executor in a state where this search is not standard practice, or working with a title company that does not run it, may close the sale, distribute the proceeds to beneficiaries, and then receive a collection demand from the state months later. At which point the estate's assets have already been distributed and the personal representative may face personal liability for failing to satisfy a known creditor claim before distribution. Right now, before this bulletin ends, send this to one person who is currently serving as executor for a parent's estate or who expects to be in the next few years. The question to ask immediately, before listing any real property for sale: has a Medicaid Estate Recovery search been run against this estate? Ask the probate attorney directly. Do not wait for the title company to catch it during closing. 5 strategies. Covering the prevention window for executors who have not yet listed property, the active negotiation window for claims that have already surfaced, and the procedural mechanisms most personal representatives never know exist. Save this video to a playlist titled Retirement Survival Manual right now. What follows is the executor's protocol that a probate attorney experienced in MERP claims would charge $3,500 to $8,000 to manage for an estate at Diane's asset level. Step number 1. Request a Medicaid Estate Recovery search before listing any property. The single most important action any executor can take, before listing a parent's home, before coordinating a closing date, before making any commitment to a buyer, is to proactively request a Medicaid Estate Recovery status check from the state's Medicaid agency, rather than waiting for a title company or the probate process to surface it. In Florida, this request is made directly to AHCA's Medicaid Estate Recovery Program unit. The request can typically be made by the personal representative, providing the decedent's name, date of death, and Medicaid identification number if known. AHCA's response time varies, typically 2 to 4 weeks, which is precisely why this request must be made at the start of the probate process, not after a buyer is already under contract with a closing date 30 days out. For Diane, requesting this search in April 2026, when she opened probate, rather than discovering the claim through the title company's search in July, would have given her 3 additional months to negotiate the claim, request the itemized accounting, and identify the billing discrepancies, all before any buyer was involved and before any closing date created external time pressure. The negotiating leverage of an executor with months of runway is substantially greater than the negotiating leverage of an executor facing a closing date in 27 days. State nuance. Every state's Medicaid agency maintains some form of estate recovery unit, though the specific contact process varies. In Wisconsin, where we have followed a prior case in this series, the Department of Health Services Estate Recovery Program can be contacted directly at the start of probate. In Ohio, the Department of Medicaid's Estate Recovery Unit operates similarly. In every state, the proactive inquiry, made by the executor, not waited for from the state, is the single highest leverage action available. Step number 2, request the itemized accounting, your right under federal and state law. Once a MERP claim is identified, whether discovered proactively or through a closing search, the personal representative has the right to request a complete itemized accounting of the claim from the state Medicaid agency. This is not a courtesy. Under Florida Statute Section 409.9101(5) and parallel provisions in most states implementing statutes, the agency must provide documentation supporting the claimed amount upon request. The itemized accounting should show every individual payment the state made on the decedent's behalf, the dates of service, the facility or provider for each payment, and the specific program category, nursing facility services, home and community-based services, etc., under which each payment was made. This documentation is the foundation for identifying billing errors, coverage gap discrepancies, and improperly included charges, exactly as Diane's attorney did in identifying the $6,840 coverage gap charge and the $4,200 Medicare-eligible hospital charge. Do not accept a lump sum claim figure without requesting this itemization. State Medicaid agencies process thousands of recovery claims using automated systems that pull data from multiple payment databases, coverage gaps, dual eligibility periods, and provider billing corrections are common sources of error that an itemized review can surface. Diane's claim was reduced by 11.7% purely through this documentation review before any settlement negotiation began. State nuance. The specific statutory citation for the right to request itemization varies by state. In Florida, it is Section 409.9101(5). In Virginia, where we followed a prior case involving the Department of Medical Assistance Services, the itemization request process operates under similar transparency provisions in the Virginia Administrative Code. Every personal representative should confirm the specific request mechanism with a probate or elder law attorney licensed in the decedent's state. Step number 3. The closing delay strategy, protecting the sale. While negotiating the claim, here is the timing strategy I told you to hold. When a MERP claim surfaces close to a scheduled closing date, as it did for Diane 27 days out, the executor has options beyond simply paying the claim in full to allow the closing to proceed on schedule. Option 1. Request the buyer's agreement to a short closing extension, typically 2 to 4 weeks, specifically to allow the claim negotiation to proceed. Many buyers, particularly those not facing their own hard deadline, a lease expiration, a competing home sale, will agree to a reasonable extension when the reason is clearly explained as a standard estate administration matter, which it is. Option 2. Proceed with the closing on the original schedule by placing the disputed claim amount, or a negotiated estimate of it, into an escrow holdback. The title company holds the disputed amount in escrow rather than disbursing it to the estate, while the executor's attorney continues negotiating with AHCA. Once the final claim amount is determined, whether through the itemized accounting review, a negotiated settlement, or a formal appeal, the escrow is released according to the final resolution, the agreed amount goes to AHCA, and any remaining balance is released to the estate. This escrow holdback strategy is what Diane's attorney ultimately used. The closing proceeded on July 28th as scheduled, $87,470. AHCA's reduced claim figure at the time of closing DAR was placed into escrow. The remaining sale proceeds were distributed to the estate for eventual distribution to Diane and her siblings, while the elder law attorney continued negotiating the final amount with AHCA over the following 6 weeks. State nuance. Escrow holdback arrangements for disputed creditor claims are a standard real estate closing tool available in Florida and most states, though the specific mechanics and the title company's willingness to facilitate the arrangement vary. Some title companies require a formal indemnification agreement from the estate before agreeing to an escrow holdback closing. A probate attorney experienced in MERP negotiations will know which title companies in a given market are familiar with this process and can move efficiently. Step number 4. Formal negotiation and settlement. Reducing the balance beyond the itemization. After the itemized accounting review reduced Diane's claim from $94,310 to $83,270, her elder law attorney pursued formal settlement negotiation with AHCA for the remaining balance. Florida, like many states, has administrative flexibility to settle estate recovery claims for less than the full amount when the estate demonstrates limited assets, when full recovery would create hardship for beneficiaries even outside the formal hardship waiver criteria, or when the cost and time of formal collection proceedings would exceed the marginal recovery the state could expect. The negotiation argument Diane's attorney presented, the estate's total value after the house sale, was approximately $271,000 minus selling costs. 3 adult beneficiaries. A negotiated settlement that allowed the family to retain a meaningful inheritance while the state recovered a substantial portion of its expenditure served both parties better than a protracted formal appeal that would have cost the estate additional legal fees and delayed final distribution by months. AHCA agreed to a final settlement of $76,500, a further reduction of $6,770 from the post-itemization figure of $83,270, representing a negotiated 10% additional discount common in estate recovery settlements, where the state has limited collection leverage against an estate that has already distributed most of its assets through a completed sale held in escrow. Total reduction from the original claim to the final settlement, $94,310 to $76,500, a a $17,810 reduction, representing 18.9% of the original claim amount, achieved through itemization review, billing error correction, and formal negotiation, without ever requiring a hardship waiver Diane did not qualify for. State nuance. Settlement willingness and typical discount ranges vary significantly by state. States with larger MERP recovery operations and more standardized settlement protocols, Florida, Texas, California, tend to have more predictable negotiation outcomes. States with smaller or less developed recovery programs may have less administrative flexibility to negotiate, requiring a more formal appeals process to achieve any reduction. Step number 5. The prevention instrument: what Rosalind could have done while she was alive. The final strategy is not for Diane. It is for every viewer watching this bulletin whose parent is still alive, still has legal capacity, and still owns a home that could one day generate exactly this scenario for their own children. Rosalind Castellano's home, like the Burroughs family's home in our prior Virginia bulletin and the Garner family's home in our prior Louisiana bulletin, could have been protected from MERP recovery entirely through a transfer on death deed, a ladybird deed, or an irrevocable Medicaid asset protection trust, funded at least 5 years before her nursing home admission. Florida recognizes the ladybird deed statewide, and Florida's homestead exemption already provides constitutional protection against MERP recovery for a primary residence in many circumstances, meaning Rosalind's specific situation may have qualified for protection that was simply never executed. This is the lesson embedded in every executor's discovery at closing story. The protection was available before the parent's death, often for under $1,000 in legal fees, and the absence of that protection is what produces the $17,810 negotiation, the 27-day scramble, and the reduced inheritance that Diane and her siblings ultimately received. The instruments exist. They require a parent with capacity, a family conversation that acknowledges mortality, and an elder law attorney engaged before the diagnosis arrives, not an executor scrambling to negotiate after the death has already occurred. State nuance. Florida's homestead exemption under Article 10, Section 4 of the Florida Constitution provides some of the strongest MERP protection in the country for a primary residence. But this protection has specific requirements regarding the property's use and the recipient's intent to return, and it does not automatically apply to every Medicaid recipient's home without proper estate planning. A Florida elder law attorney should review any Florida homeowner's specific situation to confirm whether homestead protection applies, or whether additional instruments like a ladybird deed are needed to ensure the protection survives into the estate. Let me bring Diane back one final time. The closing on the Tampa house occurred on schedule, July 28, 2026. The buyers moved in. The escrow holdback of $87,470 was released according to the final negotiated settlement in mid-September, $76,500 to AHCA. $10,970 returned to the estate. Diane and her siblings received their final distribution in October, 7 months after their mother's death, 3 months later than they had originally expected, but with $17,810 more than the original claim would have left them. Diane kept 3 of her mother's ceramic birds. The rest went to her sister and brother, one collection split 3 ways, the same as the house's proceeds. The orange tree belongs to someone else's family now. What Diane knows now that she did not know in April 2026 when she opened Probate: ask for the Medicaid Estate Recovery search immediately before listing any property. Request the itemized accounting the moment any claim surfaces. Know that an escrow holdback can protect a closing timeline while a claim is negotiated. Know that the claim amount is a starting position, not a final number. And know that the entire scramble could have been avoided if her mother had executed a ladybird deed in 2021, when she was still healthy, still capable, and still 5 years away from the Medicaid look-back window that would have made the protection ironclad. This channel publishes early warning bulletins within 48 hours of a Florida AHCA policy change to estate recovery procedures, a federal CMS guidance update affecting executor notification requirements, a state legislative change to the itemized accounting or settlement negotiation process, or a court ruling on title company liability for failing to surface MERP claims before closing. When those changes land, you will know here before your probate attorney's next client newsletter. Your sources are free and public. Social Security Act Section 1917, B. The federal MERP mandate and the hardship waiver requirement is at ssa.gov. Florida Statutes, Section 409.9101. Florida's specific implementation, including the itemized accounting right, is at leg.state.fl.us. If you are managing an estate in another state, search your state's statutes for the parallel Medicaid Estate Recovery implementation. Every state has one, and every state's personal representative has rights similar to the ones that reduced Diane's claim by nearly $18,000. Be the executor who requests the Medicaid Estate Recovery search on day one of probate. Don't be the executor who learns about it from a title company 27 days before closing. I'll see you in the next bulletin.